Hello, this is Professor Keith Ross from the John Jay College of Criminal Justice. I am a criminal justice professor, and today what we're going to be talking about is we're going to be talking about the first PowerPoint that I uploaded to my students, which is Introduction to Law and Justice. The reason why I start out with this first is because I want to sort of have like a level, even playing field for everyone. So when we're discussing concepts, at least we can recall some of those basic concepts that most of you should have learned in Introduction to Criminal Justice. So without further ado, let's just start. I am on slide number 3. And with slide number 3, we're going to start out with some definitions. First definition is the word law. What exactly is a law? Law is a set of rules. I'd ask you to underline that. It is a set of rules. And who is it formulated by? Well, it's formulated by the government for its citizens. And who interprets that? Well, the courts interpret that. What that means is that to see whether a law is valid, is it constitutionally valid, things of that nature, courts will interpret how that law should be read. The very first session that I had with all of you, I sort of gave a rundown of my syllabus, and then I asked a simple question. You're all supposed to be fierce advocates for justice because that's the motto of John Jay, and I asked the question, what is justice? And it was sort of a loaded question because I didn't really ask, well, what kind of justice? I mean, we could be talking about procedural justice, social justice, criminal justice, things of that nature. But I think for a standing definition for our classes, what we're going to do is we're going to use the definition that's on that PowerPoint. What is justice? Well, justice is the fair and impartial application of laws. So it is the fair and impartial application of those set of rules written by the government. And when we're talking about written by the government, well, who writes them? And we're going to find that out in Article 1. Well, it's the legislative branches of government. So at least on the federal level, Congress. So an idea of justice is pre-pandemic. One of the rules for New York City, if you want to take a subway train, New York City Transit Authority property, one of the rules of the New York City Transit Authority is that you are not allowed to smoke either a cigarette and or vape, electronic smoking, whatever, on a platform. So let's say I'm a police officer, I'm in uniform, there is no reason to doubt that I'm impersonating or anything. I walk up to, let's say, 4 people. And let's say 2 identify as female, 2 identify as male. All 4 of them are together. All 4 of them are smoking cigarettes. They're all doing the same exact thing. And by the appearance of the cigarettes, they look to me to be regular cigarettes, nothing else, no sort of drugs, anything like that. Let's just say they're all smoking the same exact cigarette. Let's say Newports. So there are 4 Newports being smoked. So I go up to the first person, a male, and I ask him, are you aware that you are not allowed to smoke on New York City Transit Authority property? Let's say he says yes or no. Ignorance of the law in this case doesn't even apply because there's strict liability. I issue him a summons. Second person I go up to, let's say that's the other male. I say the same exact thing. I issue him a summons. I go up to the 2 females. They're all together now. And I say, are you aware of the rules that you are not allowed to smoke either cigarettes and or electronic cigarettes or any sort of electronic sort of smoking device on the platform? And they say no. And I say, okay, no problem. Just in the future, please don't smoke on the platform. You need to put it out now. Well, now the question is, was justice, or what, did I do my job? Did I enforce the law? Now, that's sort of a loaded question. Usually when I ask this in class, I'll get a whole bunch of hands that say, well, no, I didn't enforce the law. I would argue, in fact, I did, because there were 4 people smoking. And what did I do? Did I address each and every one of them? Well, I did address the issue that they were all 4 breaking the law. The problem here is, and this is where, we have to really sort of define our terms. Police enforcement did take place. However, was justice served? The answer to that question, I would say, is definitely not. Because what happened? Well, did I apply the laws of, or the laws of the New York City Transit Authority in a fair and impartial way? Well, no. The two males got summonses, the two females got a pass. So although I did enforce the law to all four of them, justice wasn't really served because why? Two got the summons, two didn't. I wasn't being impartial. To to actually serve justice, there's really only sort of two outcomes that I see. Either all four would have received the summons or all four would have received the warning. That would have been fair and impartial. The last concept, and I'm not going to really go too deep into this concept. The concept is called the social contract. And the definition that we have here is that people surrender some of their freedoms. Now, in this case, what we're talking about is individual freedoms in exchange for protection by society. So, what we're talking about is this idea of personal liberty, the idea of my own free will versus government protections. A good example of this is that whenever we buy an airplane ticket and we want to go fly, what do you have to do before you can get onto that plane? Well, you have to pass TSA screening, Transportation Security Administration, I believe is the acronym. So you get searched in the airport. So what are you doing? Well, you're in fact giving up some freedom, some constitutional right, and we'll get into that in a little bit. For what? So you're giving up some of your personal liberty for what? Well, for the good of all. Because if you weren't searched, maybe you could bring something on the plane, some type of weapon, and maybe start causing some sort of public alarm or some sort of public mayhem. So you're giving up some of your protection, some of your individual and personal liberties for the sake of all. Slide number 4, we're going to talk about the sources of law. There are 4 sources of law, and I want you to know each of them. This is definitely a testable concept for me. The American criminal justice system is based on this concept of English common law, and that sort of makes sense. No matter what your social bent is, the facts are that the English came to the United States and sort of set up shop. Whether they did that peacefully or not, that's on you to figure out, and that's on you to read the history books. But this idea of English common law is pervasive in the American criminal justice system. Some examples of this is that we split our laws between criminal laws, wrongs against society, versus civil law, wrongs against individuals. Different types of courts, procedures of those courts, remedies or sanctions of those courts, and some definitions. Definitions, things like, well, how do we define what a felony is? How do we define what a misdemeanor is? How do we define what robbery is, what a burglary is? Are there differences between what a robbery is and a burglary? There absolutely are. Most people get this wrong because when they get burglarized, what do they say? Well, I got robbed. Usually, burglaries have to do with places, robberies have to do with people. So the English common law sort of sets up our system and it gives us definitions. Constitutions. Well, constitutions are basically sort of how are our governments set up and what rights do the citizens of that government have? If you look on the PowerPoint slide of number 4, it says, well, there's federal and state. Well, something to think about. If you are a citizen of the United States of America, well, you probably reside in one state. Most of my students reside in New York State. So right now, there is a federal constitution, and there is also a New York State constitution. Most of my students probably reside in New York City. If you reside in New York City, there is also a city constitution. However, we don't call it a constitution. What do we call it? We call it the city charter. This is a concept called federalism, which talks about decentralizing central governments. So the federal government is that central sort of government. However, it abdicates some of its responsibilities to the states. And when we start talking about those constitutional amendments, I'll get into that in a little bit. Statutes. Statutes are formal written laws. In order to be arrested for something, there has to be a law prohibiting such conduct. Let's say someone is arrested for a robbery. Well, in order to be arrested for a robbery, some elements have to take place. And what these formal written laws do is one, they define it and they define the different elements. Now, most people sometimes don't understand the difference between what a robbery is and what a larceny is. Okay, so larceny is basically sort of a blanket term, which is the removal of personal property without permission or authority to do so. If I was to grab a pen out of somebody's hand, I've committed a larceny. We'd have to figure out what type of larceny it is. At least in New York State, there are two different types of larcenies. One is called a petty larceny, one is called a grand larceny. This, in fact, would be a grand larceny because even though it's a pen and the pen is probably worth $2, $3, how did I take it? Well, I took it from the person. So even though the value is $3, let's say, the fact that I took it from a person elevates that from the misdemeanor of petty larceny to a felony grand larceny. But let's get back to robbery. So a larceny is the removal of property without permission or authority to do so. Well, so what's the difference between what a larceny is and a robbery? Well, what a robbery is, and this would be defined in the statute, a robbery is a larceny, the removal of property without permission or authority by means of either physical force or the immediate threat of force. Now, notice how I'm stating that it's not just the threat of force, but it has to be the immediate threat of force. Because if it's a future threat of force, that's not a robbery. If I say, give me your wallet or I'm going to punch you in the face next week, I have not, in fact, committed a robbery. What I've, in fact, committed is the act of extortion, and that would actually fall under the terms of grand larceny. Court decisions. Now, back in the definition of law, what did I say? Well, the government writes the law, and who interprets those laws? Well, that would be the courts. Well, court decisions fall into that, where they sort of examine the laws. A couple of court decisions that we will probably talk about in class virtually. We'll talk about Terry versus Ohio, which talks about the ability for police officers to commit to actually, what's the word I'm looking for, to conduct limited searches with less than probable cause. I believe that's the terminology that's used in Terry versus Ohio. So we'll talk more about that in a later lecture. Another court decision that probably everyone knows is Arizona versus Miranda. And what that in fact does, that establishes the rights of the accused and the rights that they have the right to remain silent and that they have the right to attorney, that they have Fifth and Sixth Amendment protections. In order to have come to this, a court had to actually examine all of this. So now we are on slide number 5, and we're going to talk about the difference between criminal law versus civil law. Where it says criminal law, do me a favor, put in parentheses right next to that PC/BARD. B as in boy, A as in Adam, R as in Robert, D as in David. I will get to it, I promise. So criminal law, P as in Peter, C as in Charlie, /B as in boy, A as in Adam, R as in Robert, D as in David. We're going to put that, I want you to associate those terms. PC stands for probable cause, BARD or BARD, and that's usually how I'm going to refer to it, refers to beyond a reasonable doubt. When someone commits a criminal law, this is a wrong against society. Things like murders and manslaughters, sexual assaults. Usually when we're terming sexual assaults, we're talking about things, at least in New York State, the concepts of rape. We're talking about criminal sex act, aggravated sex abuse, things of that nature. That if we allow this to continue on, well, what's going to happen? Well, society will be impacted negatively. The action is initiated by the state, and who would initiate that? Well, that would be a district attorney. District attorneys, you can also utilize the term prosecutor. We can sort of use those interchangeably. So the district attorney represents the state. The objective is to reform, deter, and or to bring the offender to justice. If someone is accused of an offense, they should be arrested with probable cause, and we're going to define that, and then they should have their day in court, meaning that they should know the charges being leveled against them, and if they want a trial, they should be allowed to have a trial to determine whether they were guilty or not guilty, not innocent, because there is a presumption of innocence in the criminal justice system. Usually, the phrase that I like using is that you are presumed innocent until proven guilty beyond a reasonable doubt. Punishable by arrest and or prison. I don't really like that term prison because it could be jail, it could be prison. So how about instead of prison, cross that out and put the word incarceration. Civil law. And there's torts. Do me a favor, put a parentheses right here. What I want you to do is you're going to put in P as in Peter, P as in Peter, E as in Eddie, /51. Now, when we're talking about civil laws, what we're talking about are wrongs against an individual. Usually what I like thinking about, or in the way I like teaching civil law, is most of us in here have seen those court shows on TV. Divorce court, my personal favorite, Judge Judy. She makes me laugh. Well, if we're talking about Judge Judy, usually what happens? Well, you have an announcer that's announcing the case and what sort of the really quick salient details of that case. So you have two sides. The court comes to order, and then what does Judge Judy do? Well, she listens to the first side, and the first side is going to detail what happened. And that person is going to sort of detail the wrongs that were done to him or her by the person that was accused. The judge might have questions, and in this case, usually Judge Judy has a lot of questions. And then what does she do? Well, she listens to the other side. So the action is initiated by the person who has been wronged, and the objective is compensation. So let's say we're talking about a car accident. So one person comes and tells his or her side of the story. Judge Judy, again, might be asking questions to maybe fill in whatever holes that the person that's relaying the story might have left. Now she will listen to the other side of the story. What she has to do is sort of figure out whose story just makes a little bit more sense, whose story tips the scales of justice just a little bit. And if we're tipping the scales of justice just a little bit, well, that's 51%. That's why you wrote 51. So the lawsuits which result in payment or damages or compel a class action. Since most of you are probably home, you're probably watching TV. When you do watch TV, you're going to see a whole bunch of different class action suits. Those class action suits are basically civil injunctions. Legal standards of proof. Probable cause. In probable cause, what I want you to do, put in parentheses, criminal trials. And I also want you to put arrest. Probable cause, the basic definition that I have here is standard that must be met before the police can lawfully arrest or summons. Basically, what probable cause, and a lot of people sort of try and really confuse this issue. Probable cause can actually be defined pretty easily. What probable cause stands for is that the person accused of the offense, if judged by a reasonable person with just the facts of the case at the time that the police were going to effect this arrest, did this person probably do it? Do the police have to 100% know that the person committed this offense? No. All the police have to know is that they probably did it. A victim statement is good enough for probable cause because at the time that the victim gives that statement, there's no real reason to judge their credibility unless there's some other sort of external factor. But given that there's no other external factors, let's say I have two people standing on a corner. One of the people rips a cell phone out of their hand, punches the person in the face, and doesn't even move, unfazed. The other person starts screaming, "Help, police!" And let's say I'm the police officer, again in uniform, no reason to doubt my credibility as a police officer. I show up to the scene and I say, "Excuse me, what happened?" "He robbed me." "Are you sure that's him?" "Yes." "Well, what can I do right now? Do I have to conduct any further investigation?" "No, not really. All I need to do is look at that person and say, 'Do me a favor, turn around, face the wall, place your hands behind your back. You're coming with me.' Do I 100% know that this person committed the offense? Do I know that there might be some internal factors going on? Maybe they had a previous relationship that I am, as of right now, unaware of as the police officer?" I cannot be held accountable because at the moment that I'm affecting that arrest in what's called good faith. Preponderance of the evidence, do me a favor, put in parentheses, civil trials. Tipping the scales at 51%. Let's go back to Judge Judy. What does Judy do? She weighs both sides of the story and sees which story holds a little bit more weight, which tips the scales of justice to 51%. Used in civil cases and to prove affirmative defenses in criminal court. I am going to hold off on explaining affirmative defenses, at least for a couple of my classes. We will talk about affirmative defenses for my corrections class. It's not really applicable to our work. Clear and convincing evidence. Well, clear and convincing evidence is more than preponderance of the evidence, but less than beyond a reasonable doubt, which we have not gotten to yet. The truth of the facts are highly probable. And who would determine that? Well, that would be a judge. Excuse me. These are used in administrative hearings. Administrative hearings right now, there's a lot of talk, at least in New York, about police reform and making disciplinary actions more transparent and more readily available to the public. Well, those disciplinary hearings, they are judged by clear and convincing evidence. For civilians, an example of clear and convincing evidence, well, that would be traffic court. Well, let's say you run a red light, a police officer catches you, issues you a summons for the red light infraction. Well, what do? Well, what do you have to do? You have to go to traffic court and plead out your case. Then the police officer, if he or she does show up, they will tell the facts of their story. And then what does the judge do? He or she has to weigh who has the more clear and convincing evidence. Beyond a reasonable doubt, required to convict in a criminal trial. That means a trial has been held and either a judge or jury has found the person who has been accused guilty. So they have been found guilty. They were presumed innocent, but they were found guilty beyond a reasonable doubt. This is the highest standard in law. 100% of the jury, if there is a jury, must agree on the verdict. If one person does not agree and they say that person was not guilty, a mistrial gets declared. The example that I like talking about with beyond a reasonable doubt is the O.J. Simpson case. Probably the majority of you did not see the case as it unfolded, but there have been some miniseries, there have been documentaries on the case, so we can sort of discuss the case. If you watch the details of the case, it really sort of seems like the prosecution was doing their job pretty well and establishing guilt. That OJ was at the scene of this crime. And what was the crime? Well, the crime was that he killed his ex-wife, Nicole Brown, and her quote-unquote friend. We don't know if there really was some sort of amorous relationship between her, Nicole, and Ron Goldman. So this trial's going on, and again, the prosecution is doing pretty well, sort of establishing guilt. And then at one point, the prosecution decides that what they're going to do is they're going to introduce a piece of evidence into court. And the piece of evidence that's going to be introduced into the court is a leather glove. Now, what the prosecution alleges was that this was OJ's glove, and he had it on at the time of the scene, and that there was blood on this glove. So they introduce it into evidence, and the prosecution introduces it into evidence, and then One of the defense attorneys, and this was really the turning point of this whole trial, one of the defense attorneys is the now deceased Johnny Cochran, and he puts OJ up on the stand and he asks OJ to place the glove on his hand. Now, this was a leather glove. Now, what do we know about leather when leather gets wet? Well, what happens, whether it's blood, water, whatever, once that liquid dries, leather tends to shrink. So now I don't know whether this was court theatrics or he really couldn't get it on. But OJ tries to slip the glove on his hand and gets to about here. And Johnny Cochran really, at this point, issues the soundbite that really colored the rest of this case and got OJ acquitted. And what Johnny Cochran said was that if the glove don't fit, you must acquit. And what that really meant was that if this glove doesn't fit, there is a reasonable doubt that OJ was not the perpetrator of this offense. And with that, what happened? Since there was a reasonable doubt that OJ was at that crime scene, the jury decided to vote not guilty for him. Okay, next slide. I am on slide number 7. One of the things that I find that a lot of my students do is that they use the term offense and crime interchangeably. Hopefully, once we've discussed this, you will never ever do that again. Think of offense as the balloon term that encompasses everything. No matter what you commit, whether it is urinating in public or murder, those are both considered offenses. However, at least in New York State, both of those are not considered to be crimes. So what we're going to do is let's start breaking this down. Offense is the big term. It includes everything. And under offense, there are 2 categories. Those 2 categories are crimes and petty offenses. So we have offenses here, and then what we're going to do, like the way I normally do it is I'll write offense here, put 2 lines, I'll put crimes here, and I'll put petty offenses here. So we have now 2 categories of offenses. We have either crimes or we have petty offenses. Under crimes, we can actually break that down further. And we can break that down further into 2 subcategories of crimes. There are either felonies or misdemeanors. Felonies, as a basic definition, is a crime, is an offense punishable by more than 1 year. The way I like to tell my students to think about this, think about it as 1 year plus 1 month. I do know that there are other, at least there were former colleagues of mine when I taught in the police academy, and some of my former colleagues in John Jay and other institutions like to teach it as 366 days. I don't like doing that. I like saying 1 year plus 1 day. And here's the reason. Every 4 years, what happens? Well, we have what's called a leap year. I believe we were in a leap year this year, which means we already have 366 days. Well, if you get convicted of a felony on a leap year, the minimum sentence a judge can apply is, again, 1 year plus 1 day, which would make it 367 days. Now, depending on the offense, the judge could make the sentence higher. I mean, obviously, if we're talking about the offense of murder or the crime of murder, you're more likely than not, a judge is not going to grant a minimum felony sentence of 1 year plus 1 day. Probably, maybe life, imprisonment. Maybe in different jurisdictions, different states, they have the death penalty on the books. A judge could sentence a person to death. Misdemeanors is a crime punishable by, if you read the New York State Penal Law, which has all of these definitions, it'll say a crime punishable by more than 15 days. Stuff like that always sort of drives me a little bit crazy, because what happens for my students is that they study, And what do they remember? Well, they don't remember the more than part, but they remember the number. They remember the 15. So I don't want you to remember that. What I want you to remember is that a misdemeanor is 16 days, 6 days, up to 1 year. So if a person is convicted of a felony, the minimum sentence that they can be sentenced to is 1 year plus 1 day. Can go the gamut up to life and or death, depending on the jurisdiction. For misdemeanors, we're going to do a minimum of 16 days, a maximum of 1 year. One other thing that I sort of neglected to say, if you are convicted of a felony, where will you serve that sentence? Well, you're going to serve that sentence in a state prison. If you are convicted of a misdemeanor, where are you going to serve that sentence? You're going to serve it in a city or county jail. So we dealt with offenses. We broke that down into two categories. We have crimes and we have the petty offenses. Now, we talked about the two subcategories of crimes. We had felonies and we had misdemeanors. Now, on the other side of the coin, now we have those petty offenses. So we're going to talk about violations. An offense punishable by a sentence of up to 15 days. Now, let's make this rational. So the maximum sentence I could possibly get if I was convicted beyond a reasonable doubt of a violation is 15 days. If it's a misdemeanor, what's the minimum? 16 days. What's the maximum of a misdemeanor? 1 year. A felony, if I'm convicted of a felony, what is the minimum a judge can sentence me to? 1 year plus 1 day. So hopefully it's starting to make a little bit of sense. So the maximum sentence that I can receive if I'm convicted of a felony is 15 days. However, judges have plenty of latitude, especially when we're talking about something that is quote unquote a petty offense. So maybe a fine. Maybe I was charged and found guilty of disorderly conduct. I spent the night in jail, sentence served, and let's say maybe the judge orders me to pay a fine of $25, $50. That could be a valid sentence for a violation. Traffic infractions usually require a fine to be paid. So more often than not, if I go through a red light, I'm probably not going to go to jail for that. I'm probably going to have to pay a fine for it. One thing I'd like to sort of point out, felonies, misdemeanors, and violations, all of those are considered to be criminal trials, so the burden of proof to find a person guilty of a felony, of a misdemeanor, and or a violation is beyond a reasonable doubt. When we're talking about traffic infractions, where would that take place? Well, that would take place in traffic court. So the burden of proof for that would be clear and convincing evidence. Okay, so the next thing that we're going to talk about the United States Constitution, basically the law of the land. What this does is that it sets up our system of government, and it also sets up our rights. One of the things that I like asking all of my students are, do you have rights? I've never held a class where no one raised their hand. Everyone knows that they have rights. As a citizen of the United States of America, we all know we have rights. Well, then usually what my next question is, okay, so what are your rights? And that's where people start, well, I know I have rights, but why do I need to know them? I just need to know that I have them. Well, I don't know if that's really good enough. But first things first, the United States Constitution, the first 3 articles establishes our government. Now, most of you in grade school probably had a class in government, and you learned about this. What you've learned, the way you were taught this, though, is that our government is comprised of a checks and balances type system, that no one institution of government has any more power than the other. So Article 1 establishes the legislative branch. For those of you that have ever had me before, you know that I like words. And if you look at the word legislator, you can actually sort of see what it is. Legis, legis, is a Latin word, and that Latin word stands for law. So Article 1 establishes the legislative branch. The legislative branch, they are the ones that actually write the laws. And as I said previous, we live in a federalist country, which means we have a decentralized sort of system. So We actually, at least New York City residents, are imposed by three different governments. There's a city or a county level, there is a state level, and there's also the federal level. The legislative branch makes the law on the federal level. Well, who is that? Well, that would be Congress. Article number 2 establishes the executive branch. The executive branch enforces the laws that the legislative branch wrote. This branch includes police agencies. Sort of makes sense. Well, who enforces laws? Well, police or law enforcement enforces laws. On the federal level, who heads up the executive branch? Well, that would be the POTUS, the President of the United States of America. Uh, for my New Yorkers, the New York State level, who would that be? That would be the governor. On the city level, who would that be? That would be the New York City mayor. Article 3 establishes the judicial branch. What does the judicial branch do? Well, they interpret the laws that Article 2, the executive branch, enforces, that Article 1, the legislative branch, wrote. So if there is an issue on how to read a law, it would be the judicial branch that determines that. And who is the judicial branch, at least on the federal level? Well, that would be the United States Supreme Court. And one of the things a little bit later in this lecture I'm going to want you guys to do is to be very clear, because at least in New York State and many other jurisdictions, there are also state Supreme Courts. However, those state Supreme Courts perform a very, very different function than the United States Supreme Court does. So please don't confuse them. So be clear. If we're talking about the United States Supreme Court, well, what do? They interpret law. What does state Supreme Courts do? They don't really interpret law. What they do is they conduct some sort of criminal trials, and we'll get to that. So now what we're going to do is we're going to talk about constitutional amendments, and these are really constitutional amendments that affect criminal justice for the most part. The first 10 constitutional amendments are called the Bill of Rights, and I'm going to go through most of them. I'm not going to talk about the Third Amendment, the Seventh Amendment, and the Ninth Amendment. Third Amendment talks about housing soldiers in time of war. 7 and 9 talk about civil trials. Since we are in a criminal justice program, we don't really need to discuss civil law so much. That's applicable for other types of coursework. So the first one we're going to talk about is we're going to talk about the First Amendment. The First Amendment guarantees freedom of religion, assembly, speech, freedom of the press, and or freedom to petition the government, otherwise known as suing the government. What I'd like you to do, I want you to remember the acronym RASP, R-A-S-P. And that's gonna stand as an acronym, as a mnemonic device. So hopefully that you can remember, what does the First Amendment protect? It protects RASP. What does RASP stand for? Religion, assembly, speech, press, petition for the government. So the freedom of religion. Well, we have the freedom in the United States to practice any religion as long as it does not impact some other person. If I were to practice a religion that required human sacrifice, well, that probably would not be constitutionally protected, because although I have the right to practice religion, well, what am I doing? Well, I'm impacting another person's right to life, liberty, and the pursuit of happiness by taking away their life in an effect to practice my religion. But I'm allowed to peacefully practice my religion. And certain examples of this, if you practice Judaism, you are allowed to wear a yarmulke. You are allowed to observe the Sabbath, and institutions have to respect that. One of the other things that I always sort of like talking about is there is a actual religion, and this is an established religion. You can look it up. For most of you have probably never heard of this, so you're probably going to be thinking that I'm making it up. For those of you that have heard about it, you're going to know that I'm not actually making this up. And the name of this religion is called the Church of the Flying Spaghetti Monster. Now, basically what this church is, it's sort of, or this religion or philosophy is, it's sort of a critique of Judeo-Christian Islamic religion. That if there is a God, God is as likely to be a flying spaghetti monster as it is to be the monotheist God of Judeo-Christian Islamic tradition. And one of the traditions of the Church of the Flying Spaghetti Monster is that if you are a practitioner, you are supposed to wear a pasta strainer, what I call a colander, on your head. Now, most of you are probably sort of smirking or laughing right now thinking about this. However, we have to start thinking about this. Now, if I'm wearing a colander on my head, am I impacting anybody else? No, I'm not. And there was a case, and I want to say it was North Carolina, I'm not 100% sure, where a practitioner of the Church of the Flying Spaghetti Monster went to their local Department of Motor Vehicles to apply for a license. Now, for those of you that have driver's licenses, and or at least in New York State, a non-driving ID, you know that your picture has to be on that license, and that's sort of standard for the 50 states. Well, this person wanted to take their driver's license picture with the colander. The photographer refused, and this person, this practitioner, took the DMV to court. What do you think happened? Well, what happened was that the courts ruled in the favor of the practitioner of the Church of the Flying Spaghetti Monster, because if you're going to ban a person who's peacefully observing their religion by wearing a colander or a pasta strainer on their head, then you're also going to have to ask people who practice Judaism to take off, or men of Judaism, to take off their yarmulkes. If a female Muslim is wearing a hijab, they are going to have to ask them to take that off. They don't normally do that. So again, justice has to be served, meaning that this constitutional amendment, this right to freedom to practice a religion, has to be impartially enforced across the board. The freedom of speech. Now, the freedom of speech, most people think that they can say whatever they want whenever they want, and that it's sort of protected under the First Amendment. The courts have been a little bit iffy on this. So this is a guaranteed right. However, it is not an absolute right. Here's an example of that. I can go on this lecture and say, I hate the president. I disagree with every one of his policies. Is that protected free speech? Yes, it is. I'm allowed to say that. Now, what happens if I were to say, and I'm saying this hypothetically, I hate the president so much that I want to do him harm? I do not want to do him harm, and I want to emphatically state that, so don't get the police on me. But now, what happens? Is that protected free speech? Well, that's sort of an iffy question, because what am I doing? Well, I might be inciting violence. I might be inciting public alarm. And if your speech is inciting public alarm, it is not protected under the First Amendment. The classic example usually is yelling fire in a crowded theater. If I yell fire in a crowded theater and there actually is no fire, well, excuse me, what did I do? Well, I incited public alarm. And if anyone gets injured, I'm probably going to be held liable for that. The freedom of the press means that the press is allowed to report what they want without government intrusion. Right now, in today's times, there's been sort of a debate or a question, is this actually happening? That's up to you to sort of decide. Second Amendment, the right to bear arms. So the First Amendment, I just want you to remember RASP. Second Amendment, just think guns. The right to bear arms. Now, this is a constitutionally protected right, but this also is a guaranteed right. However, it is not an absolute right. Now, again, we're talking about a federalist or a deregulated country, which means that states are allowed to come up with their own rules on how to interpret this. There are certain states that you don't need a license to carry a firearm. I think Texas is one of them. In New York State, however, in order to carry a firearm, in order to exercise your Second Amendment right, you need to apply for a license, and you need to show a reason or cause why you want that license. Is it basically for target shooting? Do you have to protect a business? Things of that nature. So, as per the United States Supreme Court, it's not an absolute right, it is a guaranteed right. Federal and state governments can regulate the right to use, sell, and possess firearms. Again, we're going to skip the Third Amendment. We'll go straight to the Fourth Amendment. The Fourth Amendment, which is probably one of the most important of our rights, guarantees freedom from unreasonable governmental searches and seizures. Okay, so first, guarantees freedom from what type of searches and seizures? Searches and seizures by the government. In this case, agents of the government. More often than not, what are we talking about? We're talking about law enforcement. We're talking about police, and in certain jurisdictions, sheriffs, marshals, things of that nature. Which means that in order for a police officer to enter your house without your consent, he or she is probably going to have to show a reason why. They can't just say, well, you know what, I thought that something bad was happening. You have to show probable cause against searches and seizures. More often than not, when we talk about searches, more often than not, what people think, they think of residential searches or building searches, but a person can be searched as well. Seizures. Well, what is a seizure? Well, a personal seizure. A lot of times, we know about seizing property, but an arrest is what? Well, that is a personal seizure. You're seizing a person's freedom. And in order to do that, a police officer, at minimum, must show probable cause that an offense has been committed, and the person who is about to be arrested is the one that probably did it. Requires probable cause for searches, arrests, and the issuance of warrants. In a later chapter, we will discuss the difference between what an arrest warrant is and what a search warrant is. Fifth Amendment. The Fifth Amendment, I want you to remember the acronym REDS, REDDS. And these are, again, some more rights that we have. So we had First Amendment, RASP, Second Amendment, guns, 4, guaranteeing freedom from governmental seizures by agents of the government. Now we have the Fifth Amendment, where we're talking about REDS. The right to a grand jury. In the second part of this lecture, which I will upload at a later time, we're going to talk about exactly what a grand jury is. What a grand jury is not for right this second, it is not a trial. Think of it more like a fact-finding mission. But if I am accused of something, I have the right to a grand jury. Eminent domain doesn't really have anything to do with criminal law. Basically, what this has to do with is that government has the right to seize property and use it for public works, but they must pay fair market value. Let's say I live in a house and the government wants to put up a superhighway. Well, they have the right to do that, and they can put that superhighway straight through my house, but they do have to pay me fair market value for my property. Double jeopardy. Most people have an idea of double jeopardy, but they sometimes get it wrong. So here's going to be my definition of double jeopardy, that you cannot be accused of the same crime twice in the same venue. Meaning, let's say I'm accused of robbery. How about this? Let's say I'm accused of murder and I'm found not guilty. Well, just because the person doesn't like this verdict, they can't get me rearrested for it on the criminal level. However, what they can do is that they can bring a civil trial against me. So I might have 2 trials. Now, O.J. Simpson, I brought him up prior. There was a criminal trial where the burden of proof was beyond a reasonable doubt and he was found not guilty. Well, the Goldman family brought a civil suit against O.J. Simpson for Ron Goldman's deprivation of life, liberty, and pursuit of happiness. In that case, he was found guilty as charged. Now, was this double jeopardy? Well, no, it wasn't double jeopardy, because even though we're talking about the same offense, what happened? These were 2 different venues. One was a criminal trial, one was a civil trial. The criminal trial takes place in a criminal court, in this case, probably California State Supreme Court, and the civil trial took place in California Civil Court. Due process. Allowing the system to work. I'm going to hold off a little bit on due process because when we talk about the very last concept in that second lecture, we'll start understanding what due process is. A real quick example, if I'm arrested, can a police officer arrest me, find me guilty, and sentence me? Well, no, they cannot, because what happened, I was deprived of due process. I was deprived of the ability of the criminal justice system to work its course, and for the accusations and for the evidence to be continually judged over and over again for admissibility and accuracy. Self-incrimination. This is the right to remain silent because anything I say can and will be used against me in a court of law. So I never really have to say anything. If I'm asked by the police, I don't have to say anything because if I do say something, that can be used against me. The Sixth Amendment, I'm on slide number 13. I don't really like the way this slide was presented. And so what I want you to do is I want you to take a look at slide number 16, and I want you to break it down into two component parts. Excuse me. One of those component parts has to do with trials. The other component part has to do with witnesses. So let's talk about that. The Sixth Amendment guarantees me, if I am accused of an offense, if I am accused of a crime, the right to a speedy and public trial by whom? By an impartial jury. Do I have to have a jury trial? No, I can elect to have a bench trial or a trial by a judge, but that is my right as a defendant, as the accused. I get to pick that. But I get the right to a speedy and public trial, meaning it has to be left open within boundaries, within reasons, and we will discuss that, especially in my corrections class. I have the right to counsel, which means I have the right to an attorney. If I cannot afford one, one will be appointed to me at no cost by the jurisdiction. And I also, and this one is the one that a lot of people forget, if I am accused of an offense, if I am arrested for the offense, I must be arraigned. And what arraigned means is that I am informed of the charges in court. So I get arrested no matter what. If I'm arrested for robbery, that doesn't mean the district attorney has to charge robbery. He or she can evaluate the evidence just like the police did, and maybe where the police charged robbery, maybe the district attorney goes with some type of larceny, let's say a grand larceny. Well, if the district attorney or if the state is charging grand larceny, then when the person who is accused of this offense goes in front of the judge, that is called arraignment. So now let's talk about the witnesses. I have the right to confront a witness, or my attorney has the right to confront a witness and to cross-examine that witness. So whatever statement a witness or a victim might give, their defense attorney, the one that represents the accused, gets to ask questions. Usually the reason is to impeach credibility and to establish that reasonable doubt. And also, I have the right to obtain witnesses in my favor, in the defendant's favor. Witnesses that will sort of concur with my side of the event or the incident. The Eighth Amendment guarantees protections from cruel and unusual punishment. If I shoplift a loaf of bread in the store, I can be arrested for that. I can be charged for that. Can a judge, let's say, sentence me to life imprisonment for stealing one loaf of bread? Well, I don't think so because that sounds cruel and unusual. Also guarantees protection from excessive bail or fines. This is going to be sort of an interesting thing because one of the assignments that I'm probably going to assign to my classes has to do with bail reform. So it might be something for you to think about. There's one other constitutional amendment that I do want to talk about, and that's going to be the 14th Amendment. Now, that's not part of the Bill of Rights, but I do think it's applicable to at least what we're talking about in criminal law. Protects citizens against abusive acts by state governments. Individual states cannot take away the rights given by the federal government under the Bill of Rights. The way I like talking about this, there was an issue where three states, and I forget which three states exactly they were, I believe Kentucky was one of them, banned the idea of same sex marriages, that you were not allowed to have a same sex marriage in that state. Well, what happened? Those people that were impacted by this, same sex couples that were impacted by this, took a lawsuit, and that went all the way up to the United States Supreme Court. And the United States Supreme Court had to look into this and sort of deal with the issue. And what the Supreme Court, in their infinite wisdom, stated was that this law that prohibited same sex marriages was unconstitutional. Because if you're going to ban same sex marriages or marriages based solely on the idea of sex or gender, well, then you're also going to have to ban other types of marriages, things like interracial marriages, obviously two different races, let's say someone Caucasian, someone African American, and also interfaith weddings, maybe someone who practices Christianity and someone who practices Islam. If you're going to allow interfaith marriages and interracial marriages to happen, you're also going to have to allow same sex marriages. So for right now, I've done slides number 1 through 15. This is going to be part 1 of this lecture. I'm going to upload this shortly. And then what we will do is we will do part 2, and that will finish slides 16 through 26. So I wish you guys all the best, and I will talk to you soon. Have a good day.